Lovely. Okay, I'll make you the host now. There we go. Thank you all.
Well, thank you, Michelle, and thank you for the opportunity to present today on this topic. I'll just hopefully share my screen. So hopefully everyone can see this. So this afternoon, I'm going to talk about hazardous workplace compensation claims, and in particular about occupational diseases. It is a bit of a niche area. It's a bit of a confusing area if you haven't dabbled in it in the past, and we'll explore some reasons why as we go through. There will be an opportunity to ask questions at the end of the presentation. I may address some of your queries throughout. So what is an occupational disease? So it's any disease contracted, potentially contracted as a result of an exposure to risk factors arising from employment. There are particular occupations, places or processes involved in some workers' employment. Oh, I've lost the sharing. I think, Michelle, I need to remain host. Sorry, Michelle, I think I need to remain host to keep sharing my screen. Sorry, just, thank you. I'll just go back. There we are. So as I was saying, there are particular occupations, places or processes involved with the worker's employment that can cause or contribute to the development of an illness or disease or the aggravation or acceleration of a pre-existing disease. Now that occupational disease may be attributable to the exposure of harmful substance over the course of employment with one or a number. So a classic one is silicosis. You may be somewhat familiar with that. Usually a stonemason or people working in the stonemason industry would have worked for numerous employers, and each exposure to respirable crystalline silica can contribute to the development of silicosis and other dust-related conditions. So common exposures can include chemicals, toxins, dust, typically those containing silica or asbestos, gas, fumes, radiation, and also sometimes biological agents. So what are some diseases that have an occupational link? So we've just provided some examples here. So as you can see, there's quite a lot of cancers that may have an occupational link. Interesting one is also Parkinson's disease. There's quite a few that can, or lung conditions that can be related to occupational exposures, particularly from dust and fumes. Also, there's some organic or infections such as hepatitis, leukemia, which is again a blood. We had an interesting case, which I'll talk a bit later about, a strep C case or infection, which actually came from a horse. Now, I don't expect you to be able to read this slide. It is very busy. The purpose of showing this, and this is just in relation to cancer, the black text represents body parts, and the red text represents known causes that, or agents, toxic agents that can cause cancer in those body parts. So as you can see, and I don't expect you to read it, as I mentioned, there is quite a lot of toxic things out there that can contribute to the development of cancer. And unfortunately, there's a lot of people out there who may have some of these cancers and not realise that their work or exposures during their work may have attributed to the cancer, and that's something we'll explore a bit today. So symptoms of occupational diseases can occur many years and even decades after the initial exposure, and it can also depend on the level and length of exposure. So you can also have a very acute, direct response to something that's happened there, then and there, but other times it can be over a period of time. Asbestos is a classic example. You can be exposed to a fibre and then maybe 40, 50 years later then develop symptoms and a condition. So some examples of symptoms that are commonly complained about by workers, and again, this will obviously depend on what may be wrong, but they are typically including headaches, dizziness, drowsiness, blurred vision, confusion, tremors, loss of consciousness, nausea, weakness, breathing difficulties, skin rash or discoloration. As I mentioned, unfortunately, occupational diseases have slipped under the radar with patients, and these are all examples I've unfortunately come across, with patients being incorrectly diagnosed or no diagnosis even given. There's been a failure to follow up on the condition, and that can either be from the doctors, unfortunately, lack of activity. It can also be the client or the injured workers failed to follow up. It can include failure to refer to appropriate imaging or a specialist, and also a failure to link to occupational exposure. And this is why occupational histories are so important. So if there's any doctors in the room, taking occupational history may not necessarily be relevant sometimes in providing treatment or referrals for further treatment. It can be particularly relevant if that means that that worker can potentially seek compensation. So it would be useful to have that sort of, they present with certain symptoms, and maybe to ask, as your knowledge builds up, whether or not they could have been exposed to anything at work. And sometimes clients don't even realise, or workers don't even realise they may have been exposed to something toxic. Another point could be that if it's a sort of an immediate or ongoing exposure, then if it's known that there could be a link, then they can address that at work, or they might have to change their job. So as I mentioned, they are particularly important, especially things like cancer and dust diseases, but really any potential condition. And as I've noted, I've come across quite a few situations where the disease or condition hasn't yet been linked to an occupational exposure. And I've had clients who have come saying, there's quite a lot of my former colleagues or current colleagues who have had, you know, Parkinson's or cancer, or just generally feeling unwell. I feel unwell too. It must have been something at work, and they don't always know, and that's where you really got to dive in, and you just learn from experience the types of questions to ask based on different forms of employment, or types of employment and natures of employment and occupations, to sort of figure out what potentially could have been at the workplace that can contribute to their particular types of symptoms. Now, again, for the doctors in the room, you've probably got all various resources available to different ways of providing occupational history or taking. One resource is that the Royal Australian College of General Practitioners does have an example. And if you go to this link, it will take you to this website. And if you go down the page, it's no longer under recent activities, a bit further down, there's an article on silicosis. So you click that, and then that takes you, if you go down the page, it'll take you to this topic here, taking occupational environmental history. So that can provide some further information. Again, this is more so for the doctors. Lawyers may have other types of questions they may wish to ask. So this is probably the biggest area of confusion. One of the, besides obviously people not realising they might have an occupational disease, the second thing is, or even if they may, they think, well, there's no way I can prove I actually caught or developed that condition at work, so there's no point pursuing it. So it's a very much a hot topic, especially around COVID at the moment. I will touch on that a bit later. So generally, and again, any law that I address today is in Victoria. There may be similar laws in other states. I'm not familiar with those, so just bear in mind that I'm only referring to Victorian law. So generally, no, you don't need to prove causation for what we call no-fault statutory benefits compensation. Common law is a little different. So all we need to show is that the nature of the employment, so again, the word nature, not the specific employer or employment or particular job that the client or the worker is exactly doing, must have given rise to a significantly greater risk of that worker or a worker contracting the disease than had the worker not been employed in the employment of that nature. So actual proof of causation from that specific job is not necessary. So actual proof of causation of the disease by reason of the particular employment is unnecessary and irrelevant. Proof relates instead to the increased risk of such a disease being contracted. There only needs to be a connection between the nature of their work, that is the tendencies, incidents or characteristics of their occupation, and the disease they are suffering. So again, going back to that silicosis example, it is known that stonemasons can be exposed to respirable crystalline silica from the stone that they are grinding or cutting or polishing. It's known that there is a link between crystalline silica and silicosis and a number of other conditions. It might also be that ordinarily someone wouldn't usually be exposed to chemicals, but it just so happened that during a particular period there was, say, a chemical fire or a chemical fire near their workplace. They happened to be exposed to the fumes from that chemical fire. So therefore you could argue, well, by reason of that incident, they've been exposed to XYZ chemicals. There must be some special risk of the onset or aggravated employment or occupation in which the worker was engaged. Now, that risk doesn't need to be high, doesn't need to be frequent or common, or unique to that particular employment. So again, another example of a special risk is known that, for example, welders are at a greater risk of developing certain types of cancers based on the fumes that are released from the particular materials used in their welding activities. In Victoria, there's something also called proclaimed diseases, and these can be sometimes a little easier to have accepted through a WorkCover claim. So they are deemed through Victorian legislation to be automatically due to the nature of the worker's employment, given their association with a particular place, process, or occupation. They will be entitled, the worker, to compensate irrespective of whether their employment actually contributed or caused that condition. WorkSafe, though, or the employer or insurer can, though, try to prove that it wasn't the case. So again, going back, I'll just show you the list in Victoria currently. Using, again, silicosis as an example, they may say be a receptionist who works remotely. So whilst we know that, yes, dust from the silicosis, or sorry, the stonemasonry activities can release crystalline silica, which can then be breathed in and cause scarring and other problems in the lung. If, say, you've got a remote receptionist who's never set foot in the factory, and then they randomly develop silicosis, maybe because they've been doing other activities outside of the workplace, then they probably wouldn't get the claim accepted, and then WorkSafe or the insurer can try and reject it. So it's not clear cut. Obviously, you need to look into the circumstances, but it can be generally easier sometimes to get these types of claims accepted, again, depending on the circumstances of your particular client. In Victoria, new legislation came in about 2 years ago, which is known as presumptive rights for career and volunteer firefighters, and more recently CFA and FRV, vehicle equipment maintenance workers. So if they've served in an operational role, so they've actually gone out on the job firefighting and driving the vehicles, and they've been diagnosed with cancer, they were automatically entitled to WorkCover compensation under the presumption that their cancer was caused by their service, so long as they were diagnosed during their service time or within the 10 years after finishing their service and after 1st of June or from 1st of June 2016. There are 12 cancers listed. I've only put 3 there just to save space, and there is a qualifying period. So, for example, if they have been diagnosed with leukemia, they must have at least served in that role for 5 years. If they've only been there for 1 or 2 years and then developed leukemia, then they wouldn't come under the presumptive rights compensation. There may be other ways that they can try and get a claim accepted, but it wouldn't be through the presumptive rights avenue. So what happens though if the workers had more than one employment that could have contributed? In Victoria, you lodge against the most recent employer in time for when the exposure may have occurred. So again, using that silicosis example, when I said at the start that a lot of workers work with numerous employers over their period of employment, you're generally lodged against the most recent one in time. If they only work there for 1 day, I can see potentially the WorkCover insurer would probably reject that. So you do really need to consider the circumstances. You might want to put one against that employer, and then if that's rejected, put one against the earlier employer, or the second most recent one. So workers and past workers, even if they've retired, can still lodge a WorkCover claim even if the following circumstances apply. Now, before I go through that list, some of those points can be technical defences to reject a WorkCover claim with your ordinary type of injury, say your backs or your shoulders and so forth. When it comes to occupational diseases, given the scenario where, for example, it could come on the symptoms decades later, you would hope that they wouldn't try and rely, because the person may have not known they were exposed or they were only recently diagnosed. So they can apply if they've been asymptomatic. Again, going back to the silicosis, that's a classic example. There are a lot of workers out there who do have changes in their lungs, who do have silicosis, but they're not demonstrating any symptoms at this stage. But most respiratory physicians will say they shouldn't work in that form of work anymore where they can be exposed to further respirable silica, which means then you put in a WorkCover claim, especially because they're going to need reviews and they can't work for a period of time until they find something else. You can still lodge a claim if they've left the jobs where the exposure may have occurred, or they've changed occupation, and even if they work for a number of different employers. They are a contractor, so long as they are deemed to work under legislation. If the employer has ceased trading, if they're retired, they were a smoker or otherwise exposed to cigarette smoke. So that's relevant, for example, if someone's been exposed to benzene, a chemical. You know, I've come across an IME and an agent said, well, he smoked cigarettes, he must have got whatever the condition was from that, because there's benzene not from his work. And even if they've moved interstate, you know, you've got to also consider a few parameters about that. If, for example, were exposed in Victoria, for the employer's connection to Victoria, even though they've moved interstate, can still put in a Victorian WorkCover claim. So in the validity or prospects of a WorkCover claim, these are some of the things that a lawyer would consider a WorkCover lawyer. First of all, well, there's no point putting in a claim unless that worker is actually a worker under the relevant legislation. Taking occupational history, including potential exposures to harmful substance. What is it that they could have been exposed to that has contributed to their conditions, or at least their symptoms? What is the employment history, including the companies, the locations and the years of employment with each employer? A classic example is in the rubber manufacturing businesses or type of occupations. Back in the day, they would use benzene. These days, not so much. So it could be argued, well, during their period of time of employment, 20 years ago or 30 years ago, that was used. That was the nature of their work. So that therefore increased their risk, whereas someone else now may not be exposed. A diagnosis, or at least the symptoms, that's really important because we need to figure out, well, what is the link between their particular condition and what they could have been exposed to? What are some occupational risk hazards to that particular condition? We can't really explore that unless we know what's wrong. And I've definitely had clients who haven't yet had diagnosis. Oh, we're back again. I think I need to be made host again. Sorry, thank you. Okay, there needs to be a known link between their particular condition and the symptoms of an occupational hazard. And I gave the example for example, benzene. That's known to be linked to blood cancers and blood conditions and the silicosis in silica. There must also be a possibility the worker could have been exposed to that particular hazard. There's no point saying, oh yes, he worked at a factory, X chemicals were there, X chemicals are known to be linked to their condition. But if that worker was never in the environment or where that legal touched or breathed any vapours from that chemical, then it'd be hard to get their claim potentially accepted. And also consideration that we may need to actually get an expert opinion. Typically, it could be an occupational physician or hygienist or a toxicologist, but it could also include oncologists, respiratory physicians, and other types of doctors, again, depending on the specific condition of the client. So what are some at-risk occupations for developing, or some common ones? So in terms of organic risk, then obviously you've got the abattoir workers, agricultural industry, veterinary workers. In terms of cancers, you can also have the welders, manufacturing, cleaners, chemical, anything that you could be exposed to, for example, a chemical. Spray painters, they're quite typically exposed to toxic fumes and they can have respiratory conditions because of that as well. Contractors, building, demolition issues, they're definitely at a risk of potentially exposure to asbestos. So just to provide you some example, I won't go through all of these, but I'll touch on a few of them. These are cases that we've had or come across, and just to put into sort of play how exactly this works. So first of all, we need eventually a diagnosis. We know what their occupation is, and then we've got to think of, well, what is some characteristic or distinctive feature or special risk to of their particular occupational employment that may have increased their risk of developing that condition? And is there then an accepted link between that hazardous substance and their condition? If there's no accepted link, then they would probably fail in getting it accepted. So going to example 3, we had a client with a strep C infection. It had an equine I guess, pathogen. So it's come from horses. He worked as a stable supervisor, and he dealt daily with horses, with their stables, around their saliva, around their waste. He did live on a farm. There were horses on that farm, but none that he were near. His kids dealt with those and they were off paddocks away. So he was never exposed to any other horses except for during his employment. That initially was rejected, but after some investigations and thanks to infectious disease that it was, or it did have, I guess, an equine or a horse association, that was subsequently accepted. Unfortunately, with that infection, he developed some quite serious consequences in relation to his heart. Another one is leukemia. So referring to the benzene, we had a worker, and I'm going to go into more detail a bit later with this example, but he worked at a plastics manufacturing company back in the day. He dealt with plastic or products that to do with making rubber products or plastic products, and part of that involved dealing with benzene. Now, benzene has been classified as a carcinogen to humans. And then last example is prostate cancer. So older men can be, I guess, prone to developing prostate cancer, but this particular gentleman, he worked as a machine operator and foreman in a styrene manufacturing plant back in the day. And he gave some very technical explanations about all the processes. But essentially, he was exposed to numerous types of chemicals. Unfortunately, he would do readings, and he kept one of the readings because he'd put in an incident report many years ago about how the readings were too high and there were leaks and so forth. And again, some of the products that he was exposed to, or the chemicals, have been linked to cancer. I didn't find a lot of studies on benzene linked to prostate cancer, but nevertheless, his WorkCover claim was accepted. So now a very topical one is COVID. So if a worker is confirmed to have COVID, rather than trying to determine if they can prove they actually caught it at work during their employment, instead we're contracting it. And there are a couple of factors that we can take into account. And I've found, especially when COVID started becoming more public or more around in the public, and even to this day, people still say, oh, I didn't know I could do that, put in a claim. I thought I had to prove causation, or that I definitely got it from my work. No, not necessarily. There may be definitely situations where it's absolutely known there's absolutely nowhere else you could have caught it except for at work. And then there's some other things where, oh, you could have caught it at work, or you maybe just caught it on the train, or walking to the shops. So we've got to take into account, well, what is the nature of their work? For example, if they work in hospitals, they work in the COVID ward, well, that's pretty obvious. That would probably simply increase their risk. Did or does the WorkSafe have any confirmed cases? It doesn't necessarily have to be staff. It could have been a contractor or a third party. It could have been a client or a patient, if that's in a hospital setting. During their work, did they come across or in contact with anyone who's confirmed to have COVID? And that person may have been symptomatic or asymptomatic, and they may have been tested positive before or after the same time as that worker. Just because they tested positive after the worker or the injured worker does not mean that therefore the injured worker gave it to that other person. The other person may have been asymptomatic, or may just not have gone and got a test, or may have developed symptoms at a later time. Did the person wear any PPE? Even if they did, was it adequate? And maybe when they were taking off their PPE, such as a mask, maybe they didn't do it in a way which could have reduced contamination, and maybe they put it down, didn't wash their hands properly, went and ate, or touched their face, or touched the door handle, and potentially spread the COVID. And another consideration, maybe in terms of process, whether or not they should be lodging a claim, is had they actually been in contact with a confirmed case, or back in the day, we don't really reveal hotspots anymore, but had they been exposed to a hotspot before any reported cases as their work, and how long ago? So quite often an agent can say, a WorkCover agent, oh, well, their husband, partner, child had it, they must have got it from there. So just to give you an example, this is one of our clients. I've changed the name for obvious reasons. So he is a 50-year-old male at the time of exposure. He was a support worker for a child on NDIS, and in 2000, he was providing support care for an unwell child. So he would go and care for them at the home. He would take the child out to appointments, out to the park. Now, our client alleged that that child was coughing and had flu-like symptoms whilst our client was providing that care for them. That's denied by the employer and the child's family. The worker subsequently started to feel unwell and then had a test for COVID. They were required to then notify the employer, who then notified the family, and then the whole family went and got tested, and the child was subsequently diagnosed with COVID. Unfortunately, our client required hospitalisation and a ventilator, and he's had numerous problems since then. The WorkCover claim was lodged. It was rejected because there was a factual dispute. Eventually, it was accepted via a conciliation process. The agent alleged, based on instructions from the employer and the worker, that the child did not demonstrate any symptoms whilst the worker was providing care. So the worker, in fact, himself was unwell and therefore must have given the symptoms to the child. However, contract tracing did not reveal, back in the day when there was contract tracing in Victoria, did not reveal that our client had been around anyone else who had tested positive, nor any hotspots, nor had he been in contact with any other children or clients. And it should be noted that you can have COVID and be asymptomatic. So even if the child didn't have any symptoms, he was positive around some point at the time when the client was caring for him. So we argue that the worker was at a significantly increased risk of contracting COVID whilst looking after that child, noting that that child also was diagnosed with COVID. So eventually that must have been accepted by the agent because the claim was accepted. It's not uncommon to come across these types of situations where it's a he said, she said, or they tested positive first, and therefore they must have brought it into the workplace or given it to the other person. That isn't necessarily the end all. You can dispute that. So we've been talking about eligibility, but what's the point even looking into this? What is the benefit to the client? So I'll only briefly tap into this, which is statutory benefits or no-fault compensation. So an injured worker with a disease may require medical and like expenses to be covered. So they may require diagnostic testing, they may require reviews by a specialist, they may require actual treatment. They may also not be able to work because of their income, because of their condition, or have to work reduced hours, or have to change career or change profession. Via in Victoria, WorkCover Insurance can help them out by paying sort of a weekly wage or weekly payments of compensation. They may also be entitled to an impairment benefit if they have an ongoing condition and it's sort of stabilised, it's not really getting any better or any worse, then they may be entitled to a lump sum benefit. And if unfortunately the worker did pass away and they had a dependent partner or children, then they may be entitled also to a weekly pension, funeral expenses, and maybe even also a lump sum. Now, when we get to common law, so that's suing the employer or another party that may have contributed to that worker's development of their condition, it is fault-based. You do need to have a sort of causative link to that, unlike the statutory benefits. In Victoria, you wouldn't bother just because someone's become ill, potentially from work, doesn't mean you automatically go and sue the employer. You've got to think about, well, did the employer increase their risk of exposure? Were they negligent? Did they fail to provide a particular duty of care? Just in a brief summary there. And even if that is potentially the case, then we've got to consider, well, only those most serious of injuries and permanent injuries can go on to sue. So in terms of diseases, a plaintiff would have to establish that it was more probable than not that exposure to whatever that hazardous substance is was a probable cause of or materially contributed to whatever their condition is. And it is more probable than not that the negligence of the employer or another party, if it's not because of the employer, was a cause of materially contributed to their claim condition. Sometimes you'll have a worker, particularly those who are retired already, who may have an accepted WorkCover claim. They get the statutory maximum for an impairment benefit claim. You probably wouldn't bother with common law then, because whatever they get for the impairment benefit, you get taken off the common law damages anyway. So it's not always a clear pathway that you're going to do common law. What other entitlements could someone with a potential occupational disease have? So even if they're not entitled to WorkCover, we can't support the increased risk of the nature of their employment, or in addition, even if the claim's accepted, they may also be entitled to benefits through their super. So it might be a total and permanent disablement claim, income protection, critical illness. If WorkCover's not appropriate, then they might be able to go via the the Wrongs Act. And also the government has had in the past and still does some pandemic leave payments. An interesting new law came in Victoria. I think it was already in a lot of other states, which is workplace manslaughter laws, which a lot of workers need to be very careful about. It's not something that your average lawyer will do. That's really something WorkSafe and the police will need to investigate. If the workplace has failed to provide an adequately safe workplace and then the person ends up passing away, then they may face jail, or the company may have quite a hefty fine coming their way. So workplaces definitely need to be careful with respect to COVID, silicosis, even also hospitals. Potentially there's risk of contamination, needle pricks and other things. So something they've definitely got to be very cautious about. So I'm just going to end on another case summary or study, just to try and put everything together what I've said today. So again, this is one of our previous clients. So he was a 74-year-old grandfather when he came to us. He'd previously worked as a machine operator for 36 years at a plastics processing factory or rubber processing factory back in the day. He would mix batches of dye, and he also worked on the mill, which was steam heated, and both areas involved the potential use of or exposure to benzene. He was also a heavy smoker. There's benzene in cigarettes, so that's why I mentioned that. He was diagnosed with myelodysplastic syndrome, or MDS, and in 2017 he had a life expectancy of about 2 years. He was undergoing some experimental treatment. Unfortunately, did live a little longer, but he did unfortunately subsequently pass away. He was diagnosed in 2008. He didn't seek any legal advice in 2015. He didn't really know at that time whether or not there was something, just that I think it was his family had done some research, and around 2015 they thought, well, let's actually go get some advice. A WorkCover claim was subsequently lodged, and it was lodged after he'd finished work, knowing his age 74, so he'd ceased work about 10 or so years previously. And because of when he had eventually put in the WorkCover claim, and also given the change of the industry, the factory had since closed down. We alleged over the course of his employment, he was exposed to benzene, both via breathing in vapours or from the steam, and through manually handling dyes, raw materials and plastics containing benzene. After some further investigations, with the thanks of a toxicologist and a hygienist, it's actually, we discovered it's more so coming from the vapours. All the client could say is, I was handling these powders and these pellets, it must have been from that. And any disease that is associated with benzol or its derivatives, which includes benzene, is a proclaimed disease. The agent didn't regard that at all, but we say they should accept the claim also on the proclaimed diseases that I mentioned before. Unfortunately, WorkCover initially, they rejected the claim, and they incorrectly tried to argue that it did not arise out of in the course of employment, which again is not the legal test. The IME stated that there is no epidemiological evidence of MDS in the plastics industry, and that cigarette smoking containing benzene may have played a role. Yes, it may have, but that isn't the legal test. And also they know the employer ceased trading in 2009, and there was no information to support his exposure. We commenced court proceedings, but fortunately were resolved a few days prior to court. As noted, it wasn't necessary to prove actual exposure, and it was immaterial that he had also smoked. Plastics manufacturing company significantly increased the risk of him developing MDS. We obtained evidence, thanks to some wonderful experts, that there was a link between the use of benzene and the plastics manufacturing industry, and also that benzene exposure can contribute or cause MDS. So as I noted, eventually they fortunately accepted the claim, and he was able to secure some medical-like expenses, and he did get the statutory maximum for an impairment benefit claim. As noted, unfortunately did pass away a few years later, and his wife then was able to recover some funeral expenses. So I've touched on a bit of a niche area. It can take a little bit to get your head around if you're not familiar. I will stop sharing, and I'm happy if anyone's got any questions to answer them. Oh, no questions. I've blown you away, I think. You will get a copy of the slides, I understand, from Michelle. So feel free to take your time to review them to help sort of understand and get your head around the law, because it is unique. And as I mentioned, and I think as Michelle mentioned, it is based on Victorian law. It might be a little different or maybe somewhat similar in the other states as well. But it's definitely a developing and growing field, especially as more and more people realise that they may have something connected to their work or a disease, a toxic chemical. And it should also be finally noted that there are always developments in research. So glyphosate, I definitely know in America, the weed killer, it's accepted generally that it can be cancer causing, not so much in Australia, but as more research comes out, then you might see more claims coming through in that area. Thank you, Michelle.
Look, that was just awesome. I learned so much, even though I'd already had a chat about this with you and read the slides. Thank you, everybody, for attending. As long as there are no questions, now's your chance to pop your hand up and ask. Awesome. Look, thank you again very much for your participation with us today. And thank you, Kehela, as usual, amazing. The recording and the slides will come out to you guys within a couple of days. Once again, thank you very much. Have a great rest of the day. Bye.
Thank you, everyone. And thank you, Michelle, for the invitation again.
Oh, you're totally welcome. Where are we? So the tech issues, by the way, that we had earlier, we've got a new team member who set this one up, and she didn't set it up completely right. So my apologies there. That's all right. It happens. I'm still learning technology myself. Take care then. Bye-bye.
Thank you. Bye.
I'm going to close this whole, I can't even close the whole meeting.
Oh, I think I'm the host. How do I make you the host?